Hi, thanks for watching. Okay, so this is my second video on Sarah Boone. Okay, now in this video, my main concern is, given how obviously narcissistic and how complicated and how difficult Sarah Boone is as a person, okay, and given that she's gotten rid of so many attorneys thus far in this case, the question is it possible to defend Sarah Boone? Okay, could she be defended? And what is going wrong in the system that's not allowing Sarah Boone to get a real representation? Okay, why is she not able to get representation in this case?
As I said, I've spent over 20 hours going through her questions, going through her list.
And real quick, for fair use credit, I'm taking this footage from Court TV's YouTube channel. This is the June 7th Orange County Circuit Court hearing where the appointed counsel, Patricia Cashman, she's moving to withdraw.
When I tried to update her with regard to the depositions that I took recently, she opted to exit the jail conference.
Okay, before the portion that I recorded, okay, that same lawyer was also complaining to the court that Sarah Boone had a lot of lists and a lot of materials and a lot of demands, and that it was using up a lot of the attorney's time. Okay, so before we get into the attorney's complaint, let's just keep in mind the attorney's complaining about the burden it is to her practice to have Sarah Boone. Okay, but then she also says, as soon as I tried to update her about recent depositions, she opted to leave the room. If I was a judge, I would say that's not acceptable. Okay, you need to tell me more detail of why she left the room. Don't tell me that you just tried to update her about the depositions, she just left the room. That's not a complete picture. You have a duty as an attorney to be candid before this court. And so you need to give me more detailed information about what provoked her to leave the room, because I'm not going to accept as a judge that you just simply told her without any detail, just updated her about depositions and she just left the room. That cannot be, and that's not a realistic statement. So right away, I'm concerned that this attorney is not being fully candid. Okay, she's not giving a fully realistic description of exactly what was the altercation that caused Sarah Boone to leave the room. And if I was a judge, I wouldn't accept that summarizing, conclusory statement where she doesn't go into any detail. Okay, that's my first impression.
When I tried to review some things with regard to discovery as to things I wanted to make sure she was aware of, she walked out.
Okay, again, I put this on the judge, not so much on the attorney. The attorney is going to always try to simplify, but it's up to the judge to hold her to her obligation of candor before the court, right? So the judge should have said, okay, Ms. Cashman, please, what is it about the discovery you were talking about, and how did the conversation go without revealing any privileged information? How did the conversation go so that she got so upset? You can't just tell me that you're just trying to offer some items of discovery that you think are important, and then she just walks out. You owe me a more complete picture. Yes, I don't like the way Cashman is describing things in such a summary fashion, but the judge has to tell her, hey, I need more detail. I understand you have attorney-client privilege, but without divulging any privileged information, please go into more detail. I need to know how you guys started not getting along.
Some of the things that she thinks are important from a lawyer perspective, perhaps I don't attach the same importance to, and you try to explain that to a client.
Okay, I'm not really happy with Patricia Cashman. Okay, she says, some things that might be important to the client that from an attorney perspective, I'm here to tell you, I've worked in the law for more than 20 years. There is no single attorney perspective. Okay, an attorney can always change their point of view. Attorney can always accommodate, even things that they disagree with. It's normal. How many times do you think in the Chad Daybell case that John Pryor argued things that he didn't personally agree with? That's part of the attorney's job, is that sometimes you have to sort of accept a position, even just for the sake of argument, okay, that may not be according to your perspective, right? And then over time, you can sort of work it out with the client that maybe you can end up discarding the idea, but at least you take it seriously, you entertain the client's ideas, and then over time you work it out. And then occasionally you even go to court arguing things that you don't personally think, but you do it because the client has insisted, and that's just part of the attorney-client relationship. So already I'm getting the idea that this Cashman, I think she probably doesn't get a lot of money for this appointment. She's probably been appointed under a system that doesn't pay a lot per hour. And I think she feels overly burdened by Sarah Boone. And I think she's just kind of tired of accommodating Sarah Boone. That's what I'm picking up. And I think the judge is in a difficult position. You can't force a person to represent someone they don't get along with, right? But I think Patricia Cashman is showing that basically she just feels like it's too much of a burden to accommodate Sarah Boone. And I'm not comfortable with it, to be quite honest.
But at this point, we're at that impasse of, if she walks out of every conference that I have with her, I'm not sure what that says about the attorney-client relationship.
Now, if I was a judge, I mean, part of me would want to tell Patricia Cashman, hey, why don't you just do a better job of getting along with her? Okay. Why don't you accommodate her a little more? Why don't you be a better lawyer? Okay. But you can't really do that because you can't force somebody to get along with somebody else, right? You can't force them. But I would say, Ms. Cashman, I'm going to give you one opportunity to be a little more candid with this court, to maybe describe in a little more detail why you're not getting along. And that would just be really just to kind of remind Ms. Cashman that she needs to do a better job of being a good advocate. Okay. But in the end, you can't really force somebody to get along. So in a way, that would just be unnecessary theater, maybe for the judge. But the bottom line is, you can't make somebody get along. But on the other hand, I'm not going to say that it sounds like Ms. Cashman is actually a good attorney. Okay, so we do have a problem here. All right. Now let's hear a few things from what Sarah Boone has to say. Okay, and then I'll kind of try to give my final opinion.
She likes to, in quotes, put things to rest all the time and constantly tells me I'm not having this conversation with you.
Okay, let me make clear, and if it wasn't clear from my last video and my earlier videos on Sarah Boone, okay, I'm not a big fan of Sarah Boone. Okay, I think she's guilty. I'm not even sure if she's guilty of second-degree murder, but I know she's guilty of at least manslaughter. Okay, there's no question in my mind. Okay, and also there's no question in my mind that she also has a personality disorder. There's no question, and she's probably a pain in the butt to work with. No question, right? But I still think that, first of all, it's not unusual for a criminal defense attorney to represent somebody with a personality disorder. That's actually kind of normal, all right? It's not unusual for a criminal defense attorney to deal with a difficult client, right? And so, when Sarah Boone talks about, how Ms. Cashman likes to put things to rest all the time, okay, and I'm not having this conversation with you, okay, it tells me probably, and this is what I'm thinking, that Cashman probably feels like she's not getting paid a lot for this work. Okay, she's probably pretty busy. She probably feels like dealing with Sarah Boone is a big burden to her. And she probably lets Sarah Boone know somehow, lets her know that it's a pain in the ass for her. And she probably is a little bit short with Sarah Boone. Okay, now granted, Sarah Boone's not easy to work with, but the lawyer is also accountable for being short with her client.
I don't understand what it is that she has against me.
Okay, I think what she has against her is probably number one, she doesn't get paid a lot for this work. She's an appointed counsel in Florida's appointed counsel system, right? So it's a very low paying job. That's number one. I think the other thing is that, probably Ms. Cashman, among other defense attorneys, everybody's different, but she's probably one of those defense attorneys that doesn't suffer narcissistic people very much. Okay, she just doesn't tolerate, self-entitled, self-important defendants, right? Especially when they're being given a free defense through the appointment system, right?
I have told her from day one that her snotty attitude was inappropriate.
Okay, let me make it very clear. Okay, I'm not a supporter of Sarah Boone. I don't like Sarah Boone personally. Okay, but she has a point. Okay, I think Patricia Cashman is kind of snotty, and I think she came off as snotty even in the way she described the situation to the judge. I think she came off as very snotty, and I think she does have a snotty attitude. And so, I'm not trying to say I support Sarah Boone, but in this moment, Sarah Boone actually has a fair point.
And I try very hard to bear with her and her attitude.
But again, you can't force an attorney to get along with somebody, right? So if you have a personality clash like this, and if it's this bad, probably the best thing to do is to terminate the attorney-client relationship, okay? So now the real question is, and this is the question that I ask myself, can anybody offer a defense to Sarah Boone? Is she so bad that it will be impossible to give her a defense? And what would a defense look like for Sarah Boone? Okay, and this is really a two-part question, okay? Because the first part of this question, it has to do with Sarah Boone's personality, right? As a personality, is it possible to give her a defense? And the answer is yes, of course. Okay. There are plenty of narcissistic, self-entitled, crazy defendants in the United States, plenty of them. And it takes a special breed of attorney. Okay. And often, yes, it's better when you have a private attorney. I'll grant that. All right. Something's different when you're getting paid for it. There's something changes and attorneys are willing to accommodate quite a bit. Or if you have, like, say, a really high profile attorney, very, very famous attorney who knows that even if they're not getting paid for a case, they're getting a lot of publicity because it's a high profile case, right? So if somebody like, I'm not going to say Jose Baez, right? But somebody like him, somebody who wants to be like him, who wants to kind of get famous, this could be a case to do it. But you'd have to maybe, not get paid, or you'd have to get paid through other indirect ways, like by, doing speaking appearances or just by getting a lot of publicity, right? So the answer is yes, of course, it's possible to represent her, but you have to be kind of sort of a better than average attorney, and you have to have the gift for accommodating really self-entitled kind of narcissistic people. And yes, there are attorneys who can do that. So number one, no question, yes, it's possible to give her a defense, in terms of her personality. But the next question is, in terms of the merits of the case, does she have a defense? Okay. And my answer is yes, she does have a defense. Okay. Now, I do analyze criminal cases for a living. That's what I do for a living. Okay. And not to toot my own horn, but I don't find it very difficult to come up with some defenses, right? And without getting into the possible mental health defenses, just the basic nuts and bolts defenses. Okay. Basically, the big question for me as an attorney is, did that suitcase get tumbled down the stairs before it came to rest, where we see the famous video where Sarah is taunting Jorge, right? I want to know if that suitcase came tumbling down with Jorge in it and then came to rest down there. Because if that was the case, okay, that could be very serious, all right? And so I would tell Sarah right away, I'd say, look, I'm not interested in what is true or what is false. Okay. I don't care whether it's true or not, but I need to know, and we're going to have to find out if the police could come up with evidence that that suitcase was tumbled down the stairs. Okay. That's an obvious question. Obviously, you can tell me it wasn't. I don't care who's right. I don't care who's wrong, but I'm here to tell you, if there's any evidence, even if it's not true, but if there's any evidence suggesting that that suitcase came tumbling down the stairs, I would say you have big problems as a defendant, right? So, our first goal as a defense team is we want to try to eliminate, or we want to try to minimize any evidence that would suggest that suitcase came tumbling down the stairs. Okay, that's our first goal. All right, and there is evidence to suggest it didn't tumble down the stairs. Okay, I understand that some neighbors or people close to the apartment were interviewed, and there was no testimony about people hearing the thudding and the loud sounds of a suitcase going down the stairs, at least as far as I understand. So if I'm wrong, you can correct me. But basically, and even if there was some evidence like that, you try to minimize that evidence. You try to create doubt about that evidence. But basically, my first problem would be, do we have evidence that that suitcase came tumbling down the stairs? That to me would be a big game killer, And so that would be my number one issue as an analyst looking at this case. Okay, so if I was working on this case, then I would have an A and a B, like plan A and plan B. And I would tell Sarah this. I would say, we have two plans. Okay, my hope is that we can go with plan A. Okay, that there's no real substantial evidence that the suitcase came tumbling down the stairs. Okay, so that's plan A, right? And let's hope that's our plan. But if there is evidence that the suitcase came tumbling down the stairs, well, then we got a plan B. Okay, and let's start with plan B, the worst case scenario. All right. In plan B, you're going to plead to something, okay? Because if you don't plead to something, you're running the risk of really having problems. Okay, so if we were going to proceed with plan B, and again, this is the worst case scenario where there's definitely evidence that the suitcase came tumbling down the stairs, okay? Then I would just try to convince Sarah that, look, you're going to have liability, okay? But we can work with you and we can make this work out, right? She's already done like 4 years, right? By the time trial's over, she's going to have done like 5 years already time served. So I would try to sell to her, look, we may get you in a situation where, if we do our job correctly, you're only going to be sentenced to, like, say 7 or 8 years. So at maximum, you're going to do like maybe a year and a half, and we could probably work something out with the court where you could get some kind of, we'll try to really guide this process to where you can get out of jail, out of prison as soon as possible. We'll do our tricks, right? But basically, even if she did plead guilty to second-degree murder, obviously you try to get her to plead to manslaughter, right? But just in case it gets to be a problem and the state doesn't want to accept a manslaughter plea, you could plead a second-degree murder, but you could focus on, in Florida, they have these things called departures, a downward departure, right? And it's not that hard to get a downward departure in Florida, right? Especially if you can prove that Sarah has, let's say, alcohol-related brain injury, right? From the way she was acting in her police interviews, okay, it wasn't just that she seems narcissistic. It's that she also seems to be a little bit brain damaged. I mean, frankly, that's just my lay opinion. But I would definitely tell her, I'd say, look, if we're looking at a plan B, like a worst case scenario, we need to get you evaluated by really good neurologists and psychiatrists, forensic specialists who can prove if you have any kind of brain damage from your alcoholism. Or if we can't prove that, we can talk about your alcoholism and maybe try to explain that you were in an impaired state. But if I were to gamble on this, I would think a really good specialist could prove that she has some kind of alcohol-related brain injury, right? And so that could be grounds to get a really good departure in sentencing, so she wouldn't have to do the actual minimum time for second-degree murder, right? So, I know they have the guidelines and they even have minimum sentences, but there's always those departures. So, if you could prove that she has some kind of, neurological condition that merits a departure, well, then, everything's fair game. And she might get as little as, like, say, a 6 or 7 year sentence if the lawyers do their job, right? So you try to sell her on that. But then, of course, if it looks like the state cannot prove that the suitcase tumbled down the stairs, all right, well, then we have plan A, and there is lots of room for a defense under plan A. Okay, so how would I approach a defense under plan A? Okay, here's how I would approach it. Okay, now, the ultimate goal would be to get her acquitted, right? Now, a good realistic attorney doesn't hold its hope in a full acquittal. You put it down as a goal, right? But then you also put down what is your expected outcome, right? And you prepare the client. You say, look, I'm going to try and get you acquitted, right? But in the worst case, you will get, let's say, you'll get convicted under a lesser included for manslaughter as opposed to second-degree murder. And for manslaughter, we'll work on your organic brain injury from alcoholism or whatever, and we'll do our magic to get your sentence as low as possible, right? Okay, but our first goal is to avoid you getting convicted for second-degree murder. That's our number one goal. Okay, I can't guarantee you're not going to get convicted for manslaughter, but we will make sure, or we'll do everything we can. Our number one goal, you will not get convicted for second-degree murder. So to understand this, we have to understand that in Florida, second-degree murder is just a millimeter different than manslaughter, okay? Manslaughter and second-degree murder are very, very close cousins, okay? The only real difference is just the degree of recklessness. So for second-degree murder, there's basically two elements in Florida, two key elements, okay? Number one element, it has to be an act that's imminently dangerous. Number one, imminently dangerous, okay? I think, well, you could argue what happened with the suitcase was imminently dangerous. I would try to argue against that, right? But that's number one. The first element is imminently dangerous. The second element is depraved mind with zero regard for human life, okay? So the second element is depraved mind with zero regard for human life, okay? And that's how you can differentiate from manslaughter, right? Because manslaughter is basically culpable negligence, which is, basically just means being very reckless. Okay, so to really break it down to a nutshell, for manslaughter, you need a disregard of human life or safety, right? So for manslaughter, it's a disregard of human life or safety, okay? For second-degree murder, it's a zero regard for human life, okay? So it's like the difference between a disregard versus a zero regard for human life, okay? And I think there's room to play with where you could argue at worst what she had was a disregard as opposed to a zero regard. You're going to have to argue that. I mean, I'm not saying you can win, but you're going to try, right? And then the second thing is that there's an added element for second-degree murder is that the act has to be imminently dangerous, okay? And now, so what I would argue that absent special circumstances, okay, there's no reason to think a person couldn't survive inside a suitcase. Now, I would admit, as on the defense, I would say, look, we can't change what's on the recording. On the video recording, it's very clear that Sarah was being a jerk to this guy, right? She didn't give a crap about him. She wanted him to be in the suitcase. She walked away from the suitcase. She left him in there. So she's a bad girl. Okay, but do we want to prove, we have to prove whether that was imminently dangerous? Okay, yeah, he was complaining, he said he couldn't breathe, but why wouldn't he be crying wolf? He's just trying to get out of the suitcase. Was he really in danger, or would a reasonable person think he was really in danger of losing his life? Okay, just because he's whimpering and crying. And guys, I realize what happened to him was dangerous, but you have to put your lawyer's hat on, and basically say, could a person reasonably think that, yeah, he's complaining, but really you're not going to die inside a suitcase. And so she could afford to maybe take a half an hour and go upstairs, right? So you try to put yourself in her position. And I think there is room to argue that it wouldn't be reasonable to expect that a person would actually die. They might be uncomfortable, they might be in distress, they might have a panic attack, but are they going to die? I mean, even I'm a little surprised, and probably the reason why he died wasn't because he was there for half an hour. He probably died because he was in there for hours. That's probably why he died. And maybe other people could be there for hours and not die, so maybe there was something special about him, or maybe he was thrown down the stairs and maybe he had some kind of injury, and combined with being in the suitcase, that's why he died. But the bottom line, let's just assume for the sake of argument, you can't prove he came tumbling down the stairs, right? So just being in a suitcase, is there any reason to believe that just being there for half an hour would kill a person? So you try to eliminate that part of second-degree murder where it's imminently dangerous, right? And then as far as like the state of mind, is it a disregard of human life, or is it zero regard for human life? You try to play in there and say at worst it's just a disregard, not a full zero regard. So you have to do what you can, but I have no doubt that a good lawyer, a good trial lawyer, could give her a solid defense. Okay, and I think a very good trial lawyer could get her acquitted from the second-degree murder, and kind of direct the case towards a lesser included of manslaughter. And I think a really good attorney could use the same argument to maybe get her acquitted, or at least hang the jury on the manslaughter. Now, that would take a good attorney, but at least, that's kind of the area where a very good attorney would work with, the level of disregard for human life, and really whether you could really expect a person, let's just take an arbitrary time period of, let's say, 30 minutes. Could you really expect a person to die in a suitcase in a span of 30 minutes? Is that really realistic? And you just have to use that argument. It's an ugly case. But a good attorney could do it. So then the question is, well, why hasn't she gotten a defense? And I think basically the problem is that this case is more difficult than your average case. Okay, it's very unusual for a person to be killed inside a suitcase, right? And because it's not a direct act killing, it's a very unusual fact pattern, and it's a high profile case. Okay, so a high profile case requires a little more, you have to be a little more nuanced in the way you defend a very high profile case. It requires, like, I'd say, more hours and more investigation, right? Because, a high profile case, it's just, the court will naturally take this case more seriously, right? So I think the way the Florida system is, where the appointed counsel system in Florida, I just don't think economically there are any attorneys on that roster for appointed counsel that are really going to be of the caliber that I think Sarah needs for this defense, right? And now Florida does have very good appointed counsel for death penalty cases, right? But for these, kind of like just regular run-of-the-mill felonies, I just think there's kind of a gap in the appointed counsel system. And until a private attorney steps up and offers to take this case, right? Or unless Florida comes up with the funds to actually appoint a very high caliber attorney to take this case, I would say, I don't expect much out of the defense, right? And so I really think the only hope for Sarah, really, I think, and I wish somebody would step up, somebody who's kind of on the level of, like, say, Jose Baez, or somebody who wants to be like a Jose Baez, who will take this case basically to make a name for himself on the publicity, right? Take it pro bono. I think that would probably be the best option, and it would at least give her a fighting chance to have, a fair trial, where she would get a vigorous defense. Otherwise, I don't expect much. So, that's pretty much my summary. Of course, I think she's guilty of manslaughter. I'm not sure if she's guilty of second-degree murder for the reasons I just explained. But, by the way, I'm not a big supporter of Sarah Boone, but I make this video in the spirit that, people deserve at least a decent defense, right? Regardless of how guilty they are. That's just part of the way our system works. But that pretty much sums it up. And I do, I guess, kind of hope, that some kind of high profile attorney will step up to this high profile case and take it pro bono. But otherwise, I guess there's not much to expect. So anyway, appreciate your patience and thanks for watching.